24, that comes to 52, nothing more. So there are two ways of looking at it. One, when we want to see the expanse of the word industry in control, then we must go back to the source, which is NC 24 list 2. Because whatever is contained therein can possibly come here. Entry 52 cannot drag more than what is there in the well or the source. And entry 24, Lord, has been analyzed in at least half a dozen cases. One was which I had cited in a very limited manner, but I just need to place that judgment and then that will answer your lordships. Now, my lord, question is this word industry in entry 24, what is the expanse of that? Because as the lordship has seen, all the cases are unanimous that word industry in entry 52 would mean the same thing as entry 24. There is a intricate and intimate link between the two, Lord, which cannot be snapped. Now, Lord, if word industry here is of limited expanse, then we can't expand the scope of entry 52 beyond industry in 24, entry 24. Now, let us see, Lord, the scope of entry.
Tikaramji says that industry covers three elements. One,
yes, widely,
raw
in a wider way, it covers three.
Raw materials, manufacture or production,
right,
and distribution.
Right.
It says that raw materials would not be comprehended within entry 52
because they are not part of industry.
Then second, they say the manufacture or production would also not be covered unless it is a controlled industry. Once it is a controlled industry, they say manufacture or production will also be covered by entry 52. But they say that even in respect of a controlled industry, distribution of the product goes to entry 33. So, in your favor, in case a industry is declared as a controlled industry, the distribution of the product goes to the concurrent list. In the concurrent list, unless there is a legislation by the center which prohibits the states from enacting
that
law,
aspect a little later.
The states are not.
That's the B part of my argument.
Therefore, for instance, you can certainly levy a fee in relation to distribution is concerned.
But the difficulty that is arising with due respect, if I can explain, is because we are trying to trace the word industry in all its expanse on its own. But what the case law from 56 onwards till date indicates is the word industry takes its color and scope and expanse and depth and breadth, whatever it is, not from entry 24. Now let us see what is there at the initial stage, what is there in entry 24 which can be taken over.
If you go to Tikaramji again, which was what we read yesterday at volume 5, page 96.
Let me kind of bear this fact in mind. In Tikaramji, the issue was of entry 33, not for the product of notified industry. Tikaramji is different. Tikaramji was a case of entry 33 because there was an entry containing foodstuff over there. And therefore, it became it fell within entry 33 list 3. Not because it was product of notified industry. Sugarcane was never regarded as product of notified industry. Your Lordship may have entry 33. Room 33. This 3. Trade and commerce in and I'm sorry. A relates to product of industry notified under idea. B relates to foodstuff, and sugarcane was traced to foodstuff in Tikaramji. And therefore they said there is an express entry here for foodstuff, therefore it won't go to industry. So Tikaramji is being misunderstood with due respects here. because Tikaramji is not a case of product of notified industry being regulated, but instead raw material of the industry, which is sugarcane. So when Tikaramji segregated the end product as well as raw material, it first went to entry 24. And therefore, what I am submitting with respect is kindly go to entry 24. And then let us carve out what is included in entry 24 in the state list. Because as I said, not source is entry 24. If the source doesn't contain something, then perhaps you can't expand the source by taking it over in entry 52. Now kindly have entry 24.
Your argument, basically, you've got the point that your argument, we'll have to hear the other side of that, is that this product relates to entry 8 of list 2.
Completely.
Right.
You don't have to go
That's
to entry
step 1. Once it relates to entry 8 of list 2, it does not fall in entry 24 of list 2. Point number 2. 3, if it doesn't fall under point number 3, the concept of industry in entry 24 is the same as entry 52, or rather entry 52 industry is the same as entry 24. So 4, since entry 24 is not applicable, likewise therefore entry 52 is not applicable.
Exactly. With due respect,
So,
I'm grateful.
That's really the 5 points which you have made. And
It's
really
also-
speaking, the whole fulcrum of your submission depends on whether industrial alcohol is an intoxicating liquor within the meaning of entry 8.
Exactly. And for that,
Because that's the first and foundational argument which you have
I'm
made.
extremely obliged. Not I had to work whole night on this, but lordships have really taken it.
So
I'm-
these are the 5 steps which you have built your whole argument on.
And this would be clear.
And you say that industrial alcohol is intoxicating liquor by saying that, well, you must bear in mind the past legislative practice, the provisions of the Government of India Act, entry 31, and how it was interpreted by the courts, the 2 British acts, which Balsara said you must look at. And therefore, Balsara says, according to you, that industrial alcohol intoxicating liquor would include liquor fit for human consumption as well as denatured spirit. That was the
Here,
what Balsara.
the lordship may add 2 more decisions relating to
One
it.
more addition to that. Industries is basically a state subject.
State.
52 is by way of exception.
Now, Lord, here the lordship may very kindly add 2 more decisions, Lord, relating to denatured spirit and industrial alcohol, which were held to fall in, Lord, intoxicating liquor under entry 8. One is perhaps not the southern pharmaceuticals.
Because those, apart from Balsara,
Yes. Southern pharmaceuticals. Southern pharmaceuticals, PDF page, volume 5,
what is the citation?
1981, volume 4, SCC 391. The relevant paras are para 6, 12 to 14.
There's really no. They say it is an intoxicating liquor.
India have para 14.
In fact, they say therefore the duty, meaning thereby probably excise duty,
Excise.
will be levied by the center.
Right.
But it's an intoxicating liquor, and therefore a fee can be levied by the state under 66.
And then in 12 said, let us see whether the impugned levy can be justified under as fee or not. That is para 12.
This sentence is.
Sorry. Go ahead, please. So, Mr. Dwivedi, you see here the product that is being discussed in the judgment is denatured. That means it is made unfit for human consumption. Right? So thereafter, although it starts off, the entire liquid, it starts off as an alcohol after molasses, it is made unfit for human consumption
By adding some.
by adding something. So that is fit only for industrial use. And we are looking at a kind of product which is alcohol and capable of human use. Is that what you are trying to
Quite right. And I'm at the same time trying to indicate is not if denatured spirit, which is made unfit for human consumption, can be regarded by the Constitution bench as intoxicating liquor, then what to say of the rectified spirit, which is it's not a denatured spirit, and we can't say it is as incapable of being consumed or not. Because not all that is needed in rectified spirit is that you put mineralized water into it and dilute the strength of the liquor from 90% to 35%, then it's drinkable. In fact, all over the country liquor is this only. There's nothing else. Country liquor is nothing but rectified spirit diluted by this demineralized water. So portability does not mean not having as it is. Portability, therefore, my submission would always mean that it must have some intoxicating element which may cause or is capable of causing intoxication. So it will include both, something which can be had as it is, plus what is capable of causing intoxication.
And those who imbibe neat, would they be called purists?
But by that definition, Lord, I do call myself a purist, Lord. Because I prefer single malts, Lord, they can't be had. Lord, if to give an example, Lord, it's very interesting. I went to Edinburgh, Lord, that's a mecca of single malt. So I'm a lover of single malt. So I went to a bar. There I wanted to put ice cube into my single malt which they served. So the bartender got annoyed. He said, "You can't have this. I mean, it's a single malt. You got to have it neat. You can't mix it with water, soda, or cube. After all, ice cube is nothing but water." So he got annoyed. That's the first time I came to know a single malt is had like that. There's a separate glass for it. It's not the normal whiskey glass. Just beside the point. I just took. Number the other is the Southern Pharma.
In relation to a human being.
In relation, obviously.
So therefore it is alcohol fit for human consumption. Is it involved then industrial alcohol? Because industrial alcohol per se is not fit for human consumption.
No, as we pointed out yesterday, Lord, the legislative history indicated that both denatured spirit as well as potable alcohol were part of intoxicating liquor. All the excise acts, the Intoxicating Liquor Act of 1910, Britain, certain acts, Bolstered Act of US, they all regarded the industrial alcohol as part of intoxicating liquor. In fact, the Spirit Act of 1870 of the of England was, they showed the awareness about denatured spirit. It is specifically mentioned as part of spirit. The local acts definitely mentioned it as intoxicating liquor includes denatured spirit. Because the reason is, as the Lordship saw in those definitions, all liquids containing alcohol are part of intoxicating liquor. That was the definition in all those acts.
Intoxicating liquor really, in your submissions, would include liquor which is fit for human consumption and liquor which is not fit for human consumption. Right? Because the intoxicating liquor in that sense in your submission is a broader concept, which is not confined only to liquor which is fit for human consumption. The only difference which arises is in regard to the taxing power.
Taxing power.
If it is alcohol fit for human consumption, the center has no control. If it is alcohol which is for human consumption,
then it goes under.
Then it goes to the states.
51 list.
If it is unfit for human consumption, the center can levy a duty, right, under entry 84. But the power of the state, once it falls under entry 8, the power of the state to levy a fee is preserved by entry 66.
To regulate. Regulatory fee can be imposed.
Whether in a given set, say a circumstance, a regulatory fee or something is an independent determination.
Right. That's an independent issue. Now, Lord, there is an interesting question which I had posed yesterday
Can
slightly.
we see Southern Farmer since we were on
Yes.
this, so we close this part now. Volume 5, page 1985.
This is judgment to 3 judges, Lord. Justice KP Sen judgment. And this is that deals with the industrial alcohol. ये तो पहले आ जाए. Judgment would make more sense if a lordship would. This judgment would.
It can come under industry as such. Under
No,
can
that's what
come
I
under
would.
entry
That's,
54 industry
that is answered.
subject to
Let's
entry.
assume at the moment it does. I'll answer that.
Yes.
Now, alcoholic liquors for human consumption, there is used to have cough syrups in large quantities and consume whatever alcohol was there in that. So, medicinal toilet preparations containing alcohol also fall in entry 8. And this is what Balsara said, and this is what Southern Pharmaceutical follows.
Point in that little extract from Southern Pharmaceutical, which says that.
Yes. Can you have para 6 more? It's very clear. This is a case where the spirit was being used for manufacture of drugs, medicinal products. And para 4 contains the challenge. Enactment of Medicinal Toilet Preparations Excise Duties Act 55 by Parliament under entry 84, list 1 of the 7th schedule of the Constitution, or the framing of the Medicinal Toilet Preparations Excise Duties Rules 1956 by the central government in exercise of their rule-making power under Section 19 of the Act for purposes of the duties of excise on medicinal and toilet preparations containing alcohol, etc. do not prevent the state legislature from making a law under entry 8, list 2 of the 7th schedule to the Constitution with respect to intoxicating liquors, or a law under 51, list 2 for levying excise duty on alcoholic requirements for human consumption. In order to appreciate the contention regarding the applicability of the doctrine of occupied field, it is necessary to examine the scheme of both the acts. Then 8. The legislative history of this central act, I'll go with that, but I'm sorry, para. Irrelevant. I would pray, Lord, kindly have it from para 12, 13, and 14. It is the charging section which gives the true index to the real character of a tax. The nature of the machinery by which the tax is to be assessed is not of assistance, except insofar as it will throw light on the general character of the tax. The charging section in Section 3 of the Central Act clearly shows that it does not seek to levy a duty of excise on alcoholic liquor for human consumption falling under 351 List 2 of the 7th Schedule, but to levy a duty of excise on medicinal and toilet preparations containing alcohol, etc. This is the central rule. Last line, not last two lines, but there can be little doubt that the Central Act must in its substance be attributed to Entry 84 List 1. In determining whether the enactment is a legislation with respect to a given power, what is relevant is not the consequence of the enactment on the subject matter, or whether it affects it, or whether it is in within substance. It is a law upon the subject matter in question. The central and the state legislatures operate in two different and distinct fields. The central rules to some extent trench upon the field reserved to the state legislature, but that is merely incidental to the main purpose, that is to the levy of duties of excise on medicinal and toilet preparations containing alcohol. Similarly, some of the impugned provisions may be almost similar to some of the provisions in the central rules, but that does not imply that the state legislature has no competence to enact the provision. It is sufficient to say, on the first ground, that the impugned legislation is confined to intoxicating liquor, that is, to ensure proper utilization of rectified spirit in the manufacture of medicinal and toilet preparations. And therefore, within the power of the state legislature under Entry 8 List 2. It further seeks to regulate the manufacture of bona fide medicinal preparations and prevent misuse of rectified spirit in the manufacture of spurious medicinal and toilet preparations containing alcohol capable of being used as ordinary alcoholic beverages. It was suggested that the provisions are identical with the provisions contained in central rules, and in particular Rule 45(1), and therefore the legislation is in the occupied field. The answer is that the enumeration of intoxicating liquor in Entry 8 List 2 confers exclusive power to the state to legislate in respect of medicinal and toilet preparations containing alcohol. But perhaps that answers Lord Justice Nagrata's query. The exclusive power cannot be taken over under Entry 24. That's what we are expanding this argument. The exclusive power of the state under Entry 8 or Entry 25 List 2 is exclusive power. It's carved out of the general power of industry, Entry 24. And therefore, that exclusive power cannot be at all taken by the center by making a declaration under IDR.
In other words, Mr. Vedi, your argument really would be this, that the bifurcation in regard to the legislative competence of the center on the one hand and the states on this subject is in respect of the levy of the duties of excise. Right? So what the centralist does is that the power to levy duties of excise on all goods produced or manufactured in India excludes alcohol fit for human consumption. That is a central list, Entry 84. Alcohol, which is duty of excise on alcohol, which is fit for human consumption, which is taken out of Entry 84 of List 1, is given to the states under Entry 51 of List 1, of List 2, right? So this is the bifurcation in regard to the taxing power. Now, insofar as the substantive power to regulate is concerned,
there is no division.
There is no division at all. The only reference to the substantive power to legislate on intoxicating liquor is in Entry 8. And Entry 8, therefore, would cover the broad gamut, whether it is fit for human consumption or unfit for human consumption.
All liquids containing alcohol.
But even though you have the power to regulate it under Entry 8, state cannot levy the duty of excise on alcohol which is not fit for human.
There is another factor, not supposing
I
levy a fee which is very harsh and excessive. Then lordships can turn around because regulatory fee is to recover the cost of regulation. But then if it is very high and very harsh, then it becomes a levy which is generally to churn out revenue, which is then becomes a tax rather than a fee.
Those are independent challenges.
That's the question. And that's an independent question. We're not concerned. Just as in synthetics too, they came to a finding that the levy imposed there was went fee on rectified spirit or denatured spirit. And their lordships felt and came to the conclusion that the levy is excessive. So they said it's a tax. If it is a tax, then they said that there is no power in the state list to tax the rectified spirit or denatured spirit, excepting 51, which is excise duty. There's no other power. Taxing power has to be expressly given. They are separate. So therefore, they said there is no power enabling the legislature to tax rectified spirit or denatured spirit. Therefore, that levy is bad because it's a tax. So that question in that decision law turns really on this.
And there is no substantive provision in list 1, either dealing with alcohol which is fit for human consumption or unfit for human consumption. Surprisingly, not surprisingly, but list 1 is advisedly silent in regard to that. There is no specific provision in list 1, except in regard to taxing. And therefore, taxation is a completely different thing.
So therefore, the question is, when they were dividing the object into two for the purposes of tax, were they oblivious of the fact that there are two separate categories? The fact is, they realized that the intoxicating liquor containing alcohol is included. All liquors containing alcohol are included in entry 8, intoxicating.
And look at the beauty of the constitutional division. Just as a aside, entry 24 of list 2 covers all industries, right? The entire gamut of industry is governed by the states under entry 24 of list 2, except whatever is declared to be a controlled industry under entry 22. Yet, though the state has full regulatory power on industry, you can't impose a duty of excise on any goods produced by your industry. The power to impose the duty of excise is given only to the center.
There was a reason for it. Not I went into that issue. Why is this? The reason is primarily because India had become independent. Now it required funds, huge funds, and excise was the biggest revenue churner at that point.
They wanted to give it to the center.
That they wanted to go to the center.
To also have uniformity.